Good evening. You're watching The Digital Age. I'm Jim Zirin. Tonight we have a really terrific show for you about the collision of law and policy in the Bush administration. In the years 2002 to 2004, President Bush sought legal approval for a number of weapons which he wished to use in the war on terror. These included surveillance, detention, and extraordinary interrogation, euphemistically called enhanced interrogation techniques. A lawyer in the Department of Justice named John Yoo wrote two memoranda, which the media later called the torture memoranda, which appeared to give legal support for the president's position. These memoranda were subsequently rescinded by tonight's guest. He is Jack Goldsmith, who was for 9 eventful months the head of the Office of Legal Counsel in the Department of Justice. He's a professor at Harvard Law School, and he is the author of the best-selling book, The Terror Presidency: Law and Judgment Inside the Bush Administration. Jack Goldsmith, welcome.
Thank you.
First, I wanted to ask you, what is the Office of Legal Counsel?
The Office of Legal Counsel is a small office inside the Justice Department. It only has 22 lawyers. And this office decides the most difficult legal questions for the entire executive branch. And when the executive branch is a giant organization, then it acts, every time it acts, it has to worry about complying with the law. And for the most difficult questions of whether the executive branch is complying with the law, the Office of Legal Counsel is charged with determining whether it is complying with the law, to make sure with interpreting the law to make sure it complies with the law.
Now, as such, you have the title of Assistant Attorney General, and you were confirmed by the Senate.
Yes.
And a number of your predecessors became Supreme Court justices, didn't they?
Justice Scalia and Justice Rehnquist were heads of the office. Justice Alito was in the office.
And I think you had a picture on the wall of your office of Attorney General Elliot Richardson.
I did. It was there when I arrived.
I see, but you didn't take it down.
No, I didn't take it down.
And was there a reason for that?
Well, it didn't occur to me to take it down, but as I say in the preface to my book, as I learned about memoranda that I had troubles with in the administration, my first reaction was to resign, because I thought that the steps needed to fix these memoranda would cause havoc within the counterterrorism policies of the Bush administration. And I thought about resigning then and later, and I thought a lot about Richardson and his not similar predicament, but somewhat related predicament when he was the Attorney General during the Nixon administration during the Watergate crisis.
That was the Saturday Night Massacre, where Nixon in 1973 sought to fire Archibald Cox, and Elliot Richardson refused to do it, so he was fired.
Right.
So is there a tradition of independence in the Office of Legal Counsel?
There is a tradition of independence. The office, by design and by culture, is charged with giving the President, the White House, the Attorney General, in whose name the office acts, detached legal advice. It hasn't always achieved this goal, and it does sit inside the political executive branch, and so there are all sorts of pressures on the office, political pressures. But the office has, to a remarkable degree over the years, in my opinion, done a good job of providing as detached advices as possible inside the executive branch.
Legal guidance for the executive branch.
Yes.
Now, are the opinions of the Office of Legal Counsel commonly rescinded?
Not often, no. There have been examples of opinions being rescinded or reversed by later administrations. It's very rare. I don't know of any cases. There may be some within the same administration.
Now, I think in your book you characterize an opinion of the Office of Legal Counsel as kind of a get out of jail free. What did you mean by that?
What I mean by that is that when the Office of Legal Counsel is asked by an agency of the government whether it can do something, and one of the questions is whether doing something would violate a criminal law, the Office of Legal Counsel offers an interpretation that says doing those acts would not violate this criminal law. And when OLC, as it's called, gives that advice, when the agency of the government, the CIA, the DOD, or anyone in the government relies on that advice, it's difficult and probably impossible for them to later be prosecuted legally for the advice that OLC gave. And so in that sense, when OLC says something is consistent with a criminal law and people rely on that in the government, it's like a de facto immunity from prosecution if the advice turns out to be erroneous later on.
So, for example, in the area of torture, if an agent of the government abroad committed an act of torture, that would violate a criminal statute, would it not?
There's a criminal prohibition on torture, yes.
And if there were an opinion of the Office of Legal Counsel on which that agent could rely and point to, that might give him immunity from prosecution.
It would make it very difficult if he relied on an opinion of the Office of Legal Counsel and stayed within the four corners of the advice.
Now, prior to your appointment to the Office of Legal Counsel, you were known as a conservative lawyer, isn't that right?
In some circles, yes.
You, I think you were called by Foreign Affairs magazine a new sovereigntist.
Right.
You went against the administration in rescinding these two memoranda. And why was that?
Well, there were many reasons why I withdrew these memos. First of all, it wasn't my job to go finding prior opinions that I thought were erroneous and to fix them. These opinions came to my attention. I thought they had a lot of legal errors in them, both in statutory interpretation and in the interpretation of the Constitution. But the thing that gave me the most concern was not just the legal errors, but the really overbroad nature of the claims in the opinions, seeming to justify all sorts of behaviors and to give OLC's approval to all sorts of behaviors that were far beyond, in my opinion, what I knew to be going on. And so it's a combination of the errors and the really excessively broad claims in the opinions that led me to take steps to withdraw them.
Well, for one thing, the opinions had a definition of torture which was not the same definition as appears in the criminal statute, isn't that right?
Well, yes, that's right. They drew on the torture criminal statute prohibits interrogations that inflict severe pain. And it's not easy to determine what severe pain means. So in other words, the torture statute allows the government, there may be other statutes that regulate this, but the torture statute does not prohibit all inflictions of pain, only severe pain. So the OLC was charged with figuring out what severe pain meant, and that's not an easy question to answer. It's a very difficult question to answer. They looked to a healthcare statute that had defined severe pain for purposes of medical, of health benefits, and so I think it was appropriate to look for other definitions of severe and severe pain in the U.S. Code. That one struck me as inapt, and it gave a definition having to do with the functional equivalent of organ failure that didn't seem to me to make sense of the statute.
Well, I think the language was equivalent in intensity to the pain accompanying serious physical injury, such as organ failure, impairment of bodily function, or even death. And that came from a healthcare statute.
It was a health benefit statute, as I recall.
Now, you've said that this definition of torture was tendentious. I think that's the word you used in the book. What did you mean by that?
Well, I don't remember using that word. Perhaps I did. What I meant was that it didn't seem to capture the only meaning of severe pain. It seemed to me to allow a lot more than I thought the statute correctly interpreted should allow. For one thing, organ failure doesn't necessarily coincide with pain. I mean, it doesn't seem to match up to the question of what counts as severe pain. And it also didn't seem to me what the drafters of the statute and the best reading of the statute was. I don't fault the drafters of the opinion for looking for other definitions in the U.S. Code. That's what lawyers do. When there's a term that they don't know the meaning of, they look for similar terms elsewhere in the U.S. Code. I just didn't think that was a very apt analogy.
The memoranda also said that there was a non-statutory basis, did it not, for enhanced interrogation techniques, and that even if the conduct went beyond what had been defined as torture and severity, the president had the constitutional authority under Article 2 to carry out this procedure.
Right. There was a lot of language in the opinion that said even if the torture statute would prohibit certain techniques, that if the president thought it was appropriate to carry out those techniques in war, he could disregard the statute because the statute in that circumstance would violate Article 2. And there were a couple of problems with that, in my opinion. One was no one in the administration, to my knowledge, was thinking about disregarding the torture statute. They were trying, from everything I knew, to go right up to the edge, but to stay within the four corners of the torture statute.
Now let's just talk about Article 2 for a minute. Article 2 says the president is the commander-in-chief of the armed forces.
So shall I explain?
Yeah.
So the argument is that, the argument in the opinion was that if the commander-in-chief on the battlefield decides that he needs to engage in certain techniques that might violate the statute, that his commander-in-chief power under the Constitution would allow him to do that and to disregard the statute. The statute in that instance would violate the commander-in-chief clause of Article 2.
And all the other federal officers take an oath to support the Constitution, but the president takes an oath which is set forth in the Constitution to preserve, protect, and defend the Constitution.
Right.
So he has an obligation to protect the country and the exercise of that obligation.
He does, and
he could torture. Wasn't that really the reasoning of
the argument was that the argument seemed to say that he could engage in torture pursuant to his commander-in-chief powers if he thought it was necessary to protect the country. Let me say that there's nothing unusual or controversial in theory about the president interpreting a statute and determining that the statute impinges on one of his powers. Lots of presidents have done that in the past. That wasn't the problem. The problem was, there were two problems. One, the interpretation of the commander-in-chief clause, in my opinion, was unsupported by anything in the law. It was extremely broad. It would have wiped out not just the torture statute, but the War Crimes Act, the Geneva Conventions, the Uniform Code of Military Justice, and lots of other statutes. And then again, the second problem, in my opinion, was that it was unnecessary to the task at hand. And that was really, so it made it all the more remarkable, in my opinion, that it had engaged in the analysis, because it didn't seem necessary to the ends that they were trying to achieve.
And it was those concerns that led you to rescind both memoranda, isn't that right?
Yes.
Now, there were two memoranda, and the first one was the one you rescinded second. The 2002 memorandum, correct, which had been authored by you, but had been signed by Bybee, who was then the head of OLC, was the last one, or the second one that you rescinded. The first one, which just became declassified,
right,
you rescinded first.
Right.
Why was that?
Well, a couple of reasons. This opinion has just been recently declassified, and it was an opinion written to the Department of Defense in connection with a project they had going on there to figure out the limits of their interrogation program. And this opinion, in my opinion, contained more errors than the other opinion. And it was more, so I was even broader and unnecessarily broader than the earlier August 2002 opinion. And also, but the reason I was able to rescind it first was because I had a sense, I knew what the Department of Defense was doing, what techniques they were doing. And the Department of Defense was doing sort of 24 techniques that were, in my opinion, clearly lawful. The opinion in question authorized things that were much, much broader. And I was able to quickly determine that the 24 techniques were legal, and therefore, what I worried about was pulling out this opinion would have a terribly disruptive effect on our counterterrorism program. So I wanted to be able to say what I thought about the interrogation techniques they were actually using. And I was quickly able to determine that those techniques were lawful. So I was able to withdraw the opinion to say what they're doing is lawful, told them not to do anything more than those 24 techniques that I had looked at and determined to be lawful without coming back to me for further guidance. And I believe that's what they did.
Now, there was a figure with whom you interfaced at the time you rescinded the 2003 memorandum, named David Addington, who at the time was, I guess, counsel to the vice president,
right,
and is now chief of staff to the vice president. Why was he functioning on Department of Justice matters?
I didn't actually speak to him about that memo, but I did about a lot of other things. I would often go to the White House to have meetings with Judge Gonzalez, the president's counsel, about national security matters. I did it almost every day, sometimes twice a day. And they had developed a policy at the beginning of the administration that David Addington would be in these meetings. I believe he was in the meetings because he was expert on national security. He had very strong views about it, tons of expertise. He had been in the CIA. He worked in the CIA and the House Intelligence Committee. He had been the general counsel of the Department of Defense. He was one of the most knowledgeable people in the government, maybe the most knowledgeable person in the government about national security law. So I think it made sense for him to be in the room. And he was in the room for just about every meeting that I had with Judge Gonzalez on national security.
Now, you often clashed with him on
we had our
matters.
Disagreements, yes. we
which,
did.
Which you relate in the book. First, just to digress for a moment, and we'll only touch on the subject because I know you can't comment on specific interrogation techniques, but there's been highly publicized a technique known as waterboarding. It goes back to the Spanish Inquisition. It was done by the Khmer Rouge in Cambodia. It's a method of interrogation where the victim, if you call him a victim, is strapped down, and then water is poured over his face, and he has the feeling he's drowning, and all in an effort to get him to give information. I guess the CIA has admitted that it used waterboarding on 3 occasions. The president has said we don't do it anymore. The Congress passed a bill not too long ago, I think in March, which outlawed waterboarding, and the president vetoed the bill. Do you think his veto was good policy?
Well, I wouldn't quite characterize the bill. What the bill would have done was, as outlawing any particular techniques, what the bill would have done that he vetoed recently was to bind the CIA to the same interrogation techniques used by the Department of Defense and their Army Field Manual. And so the law would have required them to do what the DoD does. If there are techniques, I don't know the answer to this question, if there are techniques that are legal, and there are many, the Department of Defense techniques do not exhaust the possibility for all legally available interrogation techniques. If there are techniques that are lawful and that can help in getting information from terrorists who have actionable intelligence about an attack or some harm to come to the United States, I think the United States should be able to use those techniques. And if that's what the president was trying to do, was to preserve that band of techniques short of torture, short of cruel and human degrading treatment, short of what Common Article 3 of the Geneva Conventions, those are all the lines now that you can't cross. But short of those, but more than what the Department of Defense was doing, if he was trying to preserve those techniques, and I believe he was, then I do think it was good policy. So if that's what he was trying to achieve, I think it was good policy.
Let's just go back to the so-called Bybee Memorandum, which was the second one that you pulled, the earlier memorandum, the second one that you rescinded. You clashed with Addington at the time that you rescinded that memorandum, and then you resigned. Can you tell us about that?
Well, we had a lot of clashes. This was in June of 2004. He and I had many clashes leading up to that point. And I had done some other things in connection with prior opinions that he really deeply disliked and thought was bad for the country. And so just before, so there was a large prehistory to the withdrawal of the interrogation of the June 2002 interrogation opinion. Just before I made the decision to withdraw the opinion, Addington had said to me that he pulled out a card out of his pocket, and he said he had a list of opinions that I had withdrawn, and said that the president...
Like a 3x5 index
card. A 3x5 index card that he kept next to his tattered copy of the Constitution. Said he was keeping...
Open Article 3.
Article 2.
Oh, Article 2.
Yeah, no,
not Article 3.
He focused on Article 2. David was a serious student of the Constitution. He was a principled and deeply informed student of the Constitution. I disagreed with him, but he was a formidable figure. Anyway, he suggested he wanted to know what else I was going to withdraw. He said the president needed to know because the president needed to have clear guidance. I completely agreed with this concern. I wasn't happy about causing disruption in the legal foundation for the war on terrorism. I hated doing it, and I tried to find ways not to. But what Addington was suggesting in front of a lot of people was that the president, I thought that the president and he had lost confidence in the head of OLC. And so this was just soon before. I was pretty sure I was going to resign soon anyway, and that helped me along in my resignation.
After 9 months?
9.5 months.
Do you think it would be a better regime that instead of having lawyers give opinions as to whether something is torture or isn't torture, or to try to evolve generalized definitions of what is torture, to simply say that the president, on a case-by-case basis, should make specific findings, that he authorizes specific techniques, and then the agents of the government carry out, in that particular case, those findings.
Well, let me say a couple things about that. I do believe in general, my answer is going to be yes, but I'd like to say a few things before if I could. I do believe, or maybe I should say is the answer, I do believe in general that in my time in the administration and before I got there, that lawyers were doing too much work that intersected with policy, and a lot of the time the question, what should we be doing? What's the appropriate thing to do? What's the most effective thing to do? Ended up getting confused with and confounded with what's legal and what's illegal. And that, of course, meant that the lawyers, rather than the policymakers, were making a lot of the decisions about where the lines in our counterterrorism policy should be drawn. So I do think that the lawyers had a really remarkably broad role. I think it's also very difficult. You know, there's a lot of discussion about torture's good, torture's bad, but the truth is drawing the line of what's permitted and what isn't permitted, whether it's torture or cruel, inhuman, and degrading treatment, those are very difficult lines to draw. I do think, to pick up on your suggestion, that a good compromise, and I wrote about this recently, a good compromise to the standoff between Congress and the President over interrogation would be to allow the CIA to do these other techniques that the executive branch has determined is lawful, but to have strict accountability for their use. And, for example, have the President, this is a suggestion from President Clinton actually, have the President make a finding about why these interrogation techniques are useful. This is what the President does with covert operations. Report that to the intelligence committees, and then have an after-the-fact review of whether, in fact, it was necessary, what was achieved, how the interrogations were carried out. In other words, when you get close to the line of legality in special circumstances, we still need a method of accountability to make sure we're complying with the law, to make sure it's being carried out in a prudent way. And I do think something like you suggest would be a good idea.
Now let's just move on to surveillance. Maybe we've had enough torture.
Okay.
Around 2/3 of the way through your tenure in March of 2004, there was another flap between the White House and an independent Justice Department over the surveillance program. And you were present at a meeting in the hospital when then Attorney General Ashcroft was hospitalized, I think, with a gallbladder problem, and he was visited by Chief of Staff Andrew Card and also Judge Gonzalez, and you were there, and Deputy Attorney General Jim Comey was there.
Right.
What happened in the hospital, and what was all that about?
Well, I'm just going to call it a highly classified program. And there was, Attorney General Ashcroft had gone in the hospital about 5 days earlier with, as you say, a very bad case of gallstones and pancreatitis. He had had surgery the day before. That meant that Jim Comey, the Deputy Attorney General, was in charge of the Justice Department. Acting on my advice and my legal analysis, which I had vetted with him and with the Attorney General before he got sick, Jim informed the White House that the Justice Department could not reapprove a certain program the way it had been going before. And the deadline for reapproval was the next day. And so Gonzalez and Card were there to try to get Attorney General Ashcroft to reverse me and Comey effectively. And the Attorney General was very sick. I got there a few minutes before Card and Gonzalez did. He was very sick. He rose out of his bed, and when they got there and basically said no, he wouldn't reapprove. He didn't appreciate them visiting him there in these circumstances, and that Comey was in charge. So he basically rejected their request.
And you can't say what the issue was.
I'm sorry, I can't.
Now, Attorney General Ashcroft's wife was there, and I think you said that as they left, she did something.
Well, it was a remarkable scene. I mean, we were all, no one could believe what was going on in the room because he was very, very sick. She was standing behind his bed when this was happening. She was very worried about him. We all were worried about him because it was a very tense, traumatic situation, and he was ill. And when they walked out of the room, she stuck her tongue out at them in kind of a display of disapproval for what had just gone on.
Did one of your heroes, Elliot Richardson, did his name cross your mind at that moment?
Well, no, I was just thinking about Mrs. Ashcroft and what a remarkable gesture it was, because it really did capture the feelings in the room.
I think you said, quote, "I was sure the government was going to melt down. No one anticipated that I think you meant the White House, was going to reverse itself."
So Thursday, they decided to go ahead without the Department of Justice's advice, and at that point, I thought that the executive branch would melt down. I was going to leave. A lot of other people above me, higher than me, more prominent certainly than I was, were going to leave, and it seemed like a standoff that was going to have a very unhappy ending. And then they just reversed themselves.
Okay, quickly, let's get to Guantanamo and detention.
Okay.
Senator McCain has advocated that Guantanamo be closed down, that they all be moved to Fort Leavenworth prison. What's your take on Guantanamo?
Well, my take is that it's probably at this point, on balance, a good idea to shut the facility, not because I think there were good reasons why they were brought to Gitmo. It wasn't the first time that Gitmo was used for dangerous persons or persons of a special status. The Clinton and Carter and Reagan and Bush administrations all used the detention facility for similar reasons. But at this point, there's so many legal problems and so many political problems with the use of Gitmo as a detention facility. And also, I believe the Supreme Court in next month or month after next is going to basically extend constitutional protections to Gitmo in any event. So one of the justifications for having them there, so they'd be outside the reach of legal process, a full legal process will be dissipated. For all those reasons, I think it will and probably should be shut. Now, I don't think I think that's just a superficial point, though, because the truth is you still got a lot of very dangerous detainees there, and I don't think the next president, whomever he or she is going to release the most dangerous of them, 100, 150 of them. I think they will be brought back to the United States. I think there would be a big political controversy about where they go. I don't think the people in Kansas want the terrorists to come to Kansas, which is one of the reasons they were put in Gitmo in the first place. And then we're going to have a debate, it might happen before the election, but certainly after the election, about what is the appropriate method and what are the appropriate laws we need to detain them over the long term.
Well, that's probably another discussion. I think it's time to wrap up, but I want to have a question for you, Jack Goldsmith. In the area of national security, what should be Trump, law or policy?
I think in almost every instance you can accommodate the two. The administration could have achieved almost everything it wanted to achieve with a much more legitimate basis if it had worked with the other institutions of our government. So I think it's usually almost always a false choice.
Thank you. We didn't have a chance to get to your other book, Who Controls the Internet, which is our beat, but it's been a fascinating discussion, and thank you so much for coming by.
Thank you very much.
And thank you for coming by. Tune in next week for more on the digital age. For the digital age, I'm Jim Zirin. Good night and all the best.